Dear friends, a minute of your attention, please. I understand we have some graduates of the school among those present. We also have the presence of expert of the school, and taking advantage of the presence, I would like to say that the fact that Tamara Morschakova is speaking before us on an annual basis is our achievement, is the achievement of the school, and it's also our objective and goal at the same time. And it's true that we are going to have the presentation of one of the most outstanding lawyers of modern Russia. She is a former judge of the constitutional law, or the Constitutional Court, sorry. And it seems to me that she is also the person and the citizen who really understands how important it is to make our country modern through the availability of independent judiciary. And I cannot think of any better member and witness to the process of the establishment of the independent judiciary in this country. And certainly I think that her presentation will arouse your attention. I think she will tell us how she organizes her talk, and when we will have the discussion. Thank you. Thank you. And good afternoon to everybody. It's true, I'm getting accustomed to that room and to the faces I see in the room. And I'm really grateful to you, to the audience, because you are always interested in learning some facts and points about law and the Russian judiciary. And I think you are not indifferent to the success and progress that our legal system makes. Well, I chose that topic, which is called the state of Russian judiciary, myself, because I think it's quite relevant. It's not something that is for textbooks. We have a lot of textbooks, but I think this is the topic for the current appraisal of the situation in our country. And the processes that we see while the judiciary develops and inside the system, those processes are not always visible. On the surface, we can see some signs and features of what's going on, but the exact meaning of the process, the meaning that may not be that actual and relevant for many people living in the country. That's the organization of courts, status of judiciary. But for those who are interested, that meaning is not always clear too. And the topic, which again is entitled "The State of the System, Judiciary System," that topic is not new on the agenda. On the contrary, we've been talking about that for many years. We understand that unless there is a sound judiciary, no economic development is possible, and no person would feel protected and secure. And without independent judiciary, the state and the power will be out of control, and they will have a temptation to usurp the power in certain hands or embody the power in specific phases, unless it is controlled by the public, by the society, through the judiciary. So that's the judiciary, and the entire world shares that assumption. Is something that is prerequisite for the democratic state. So the state and the status of judiciary is something that is to be important to all of us living in the country. Sometimes it's achieved through power struggle, and each side is interested in seeing the judiciary more or less in very close to their idea about the judiciary. So I would make some introduction, but my intention is to leave enough time for discussion, for questions and answers, for your comments. So without any delay, I'm going to start with the description of the processes that are underway in the judiciary system now, if you don't mind. Well, I hate starting from a very tough premise, but you cannot concentrate and focus the attention of the society unless you say that. And we should really see what's happening to the judiciary. And that tough statement I mentioned is that the Russian judiciary system has been ruined. And we should really understand what were the framework and content of the construct that was entitled Russian Judiciary, Russian Courts, just to see what has been left and make your judgment if I'm correct in my statement, in my said statement, I would say. In fact, the judiciary, the courts, it's not all the instruments for judgments. In the concept of European law, in the concept of human rights, international notion of human rights, it's, the notion of the judiciary is an autonomous notion, and well recognized because anything can be referred to as judiciary or courts, but it's only the body that is characterized by certain signs, specific signs that would determine the organization, and the activities of the judiciary would fit into the definition. And if it doesn't fit into that definition, then it would imply that there is no judiciary system at all. And having said that, I would invite you to recall what those signs and characteristics are. Very often, talking about judiciary, we say without thinking about the independence of the judiciary and courts. And that's not something that is hypothetical or theoretical. On the contrary, that's the matter that is realized on a daily basis in the specific norms of legislations, in specific attitudes and behavior of people, and in specific treatment of the judiciary by the power. There is a very old episode, and that's the story when German emperor that had recognized independence of the judiciary, his subjects on the following day ran to him saying that one of his subordinates won the dispute about the ownership to the plot of land in court. So the subjects came to him asking, "What shall we do?" And that great emperor, and that's why he is referred to as the Great, "We will execute the ruling of the court. So we will give that plot of land to the person who the court decides it belonged to." So that's the treatment of, or the attitudes of the power to the judiciary, to the courts, that we've been dreaming of. But that's precisely what expresses the independence of judiciary and the courts. And in order to ensure such a situation, declarations alone are not enough. We should say that our Russian constitution stipulates all necessary attributes that are supposed to turn Russian judiciary into independent, self-sustaining, and that is playing the role of checks and balances to the other two branches of power, since it's precisely what the Constitution reads. And at the same time, the judiciary would also perform its mission to protect human rights from the power. And similar provisions are incorporated into the Russian constitution, since the rights that determine the content of the activities are ensured by the justice. And that's always the main objective of any justice, any judiciary. And that's the set of values that they pursue. It's not always that it's the application of law that's the main task of the judiciary. It's not just the courts are just playing the role of an intermediary between legislators and the executive branch. But for the judiciary, it's very important to proceed from its most important set of values. It's not ensure the dictatorship of law or the rule of law, but it's supposed to ensure the rights and freedoms of the people. And the division of powers is based on that idea. It's not the division of labor into physical or intellectual labor. The division of branches of power is proclaimed so that it's supported by the rest of the activities, and so that the legislative and executive branches of power are constrained through the judiciary. The Russian constitution recorded a very high status of Russian judges. She included in such principles as independence, continuity, invincibility, but the legislations that specify constitutional norms a long time ago began containing such provisions that set barriers to courts to implement that their constitutional status. And it didn't happen yesterday. I think from the very moment when the Russian constitution came into force in 1993, there were attempts and steps made to let legislators depart from the constitutional principles. Just a few examples. For instance, a Russian judge who was supposed to stay in his position so that cannot be changed or replaced till the retirement age. That judge all of a sudden found himself in the position of a bureaucrat who is employed in court for some time only. First the term was 5 years, then the term was even further reduced to 3 years, so that the executive power could see if that judge would fit us or not. So judges were not appointed for life, no matter how hard the Constitutional Court tried to change the situation. We provided all the arguments that that would not do. And if that judge has the person in that position does not violate the code of conduct, then there's no pretext to replace such judges. But it so happened that the initial term for a judge in the position was only 3 years, and we sometimes say that judges, they are all powerful, they can do everything, and that judges are out of control. But that's a totally wrong picture. I can assure you that a judge has fewer rights to defend themselves than any other citizens has. And I think it's only appropriate if a judge can protect himself in court, but that right is not entitled to them. And the judge can appeal only to the bodies of judiciary community, and that judicial community is another invention, in quotation marks, that was distorted in the times when the judiciary was taking shape, because the judicial community made up of 2/3 of judges, but according to international standards, those communities are to be made up of by judges only by half. But the judicial communities are manned and organized in such a way that they fully depend on judicial bureaucracy. They are set up at some judicial level in the subject of federation, in the regions, and courts pay for the expenses of those judicial communities, and members of those communities who are not judges but are appointed from elected from public, they are paid for their work. Even all the office utensils are paid for and provided by higher courts, and it's not appropriate, since chief justices of those courts are the main initiators they file cases against those judges who do not satisfy the requirements of some higher bodies and agencies, not because they make bad rulings, wrong rulings, but because of a judge being in opposition to some judicial act that judge cannot agree to, and which the judge believes is contrary to the laws and the Constitution. And the judicial community says, well, it's not politically correct, and by saying so, you undermine the competence and authority of judiciary. Please leave your position. Well, some measures of defense and protections can be taken, but in our case, we ruined even those means of protection that we had invented and believed it was our achievement. Recently, the disciplinary body was established, and it was a very important step, and it became part of the judiciary. So a judge, which his colleagues believe is not trustworthy and is to be fired, that judge can appeal to that disciplinary body so that his dispute can be appealed. And I would say that in half of the cases that the disciplinary body considered, they satisfied the appeals of those judges. But this particular body is now also shut down, and it's withdrawn, and judges can appeal only to the Supreme Court of the Russian Federation by the disciplinary board. And it does not make protection guarantees enhanced for a particular judge. And steps to diminish judiciary status were taken throughout the history and existence of the Constitution of the Russian Federation that had proclaimed that high status of a judge, of judiciary. They affected various aspects of the judiciary. At some point, a law of the Russian Federation was passed saying that judges that had been appointed for life before, so before death or before retirement age, so it read that the retirement age is to be fixed as 65 years. That law was reviewed even by the Commission of Venice, and it was said that that provision was correct, and 65 years is the reasonable age, but that Venice Commission didn't receive all the documents that were generated while the draft law was being passed. And in some of the documents, some provisions read that the rules would apply not in the future, not to the judges that would be appointed till the retirement age of 65. But those rules would apply to all acting judges who enjoyed their status earlier on entirely different grounds. So it was the first round of cleansing of purges in the judiciary system. Just 5 years later, legislators, having removed all those who they didn't want to see in the judiciary system, increased the retirement age again. They said 65 years is not reasonable. They can stay in their positions till the age of 70. So we can see that the trend is such that it is the power that can determine the status of judges and introduce any amendments they like, even and it would apply to those judges who are still in office, whose term has not expired. Similar rules appeared later, and lawyers refer to that as the law of a single judge. We have plenty of such laws in the judiciary that fall under the category. And it all began when the authority of the constitutional judges were made indefinite, but only for 5 years. It was in effect for 5 years only, and then that law was abolished. It read in new version that it would be indefinite, the terms would be indefinite only for those judges who reached the age of 70 only during their term. So that was the law, and that was entitled and called the law of a single the judge of a single law. And then similar rules were drafted when legislators, I stress legislators, that the retirement age would not apply to such persons as the president of the Constitutional Court of the Russian Federation, but sometime later another law was passed when the retirement age wouldn't apply to the president of the Supreme Court, and all thought that why it didn't apply to the other higher court, what was the Russian high arbitrage or the commercial court. But soon it became clear that the explanation lied in the subsequent legislations which abolished the high commercial court in the Russian Federation. Perhaps it wouldn't have been that terrible, but further on, another important norm was recalled, and that's the succession of the presidents of courts or chief justices in all other courts of the country. So some of the rules read that chief justices can be appointed to their positions in succession, but not more than for 2 times. But this norm was also withdrawn later on, and chief justices can be appointed for their position in succession, but not more than 2 times was deleted from the provision. So now we have the Chief Justice of the High Moscow Court, and that Chief Justice will stay in that position forever, because really we cannot see how people can be changed there. But what is the most critical, earlier we had the situation then the Chief Justices were appointed forever and for life, And some arguments read that it would be just the slavery for the entire life. So they would have to stay, all other judges will have to stay under the authority of a single judge. But it so happened that having departed from the previous stand, we have introduced even the worst norm. There is no position of the Chief Justice for life, but now the fate and the destiny of that Chief Justice is decided every 5 years by those who appoint the Chief Justice. And you can understand what impact it has. So that is the picture that made the situation quite vague. It eroded, actually, the exact status of judges, and the situation continues. That special status in the judiciary that our people sometimes refer to as ability to do whatever judges like.
This is indeed has been upheld by the Constitutional Court, whereby this is not a personal privilege of the judge, but the privilege of the citizens, who, in the first place, need an independent judiciary. Because if the judge is not independent himself or herself, how can he possibly uphold the rights and the freedoms of the citizens, in spite of the representatives of the executive? Or, for that matter, the representatives of such a clan, to use the word, an illegal or an anti-legal clan, which is resorting to corruption. However, the judge is not immune to any of these dangers, and I believe that to everybody's chagrin, the judiciary system had a decisive blow when the Russian Federation adopted a law which was entered into force last year, whereby the amendments to the Constitution, whereby a new judicial organ or body sprang up. And we're not talking about the unification of the Supreme Court. The unification of the Supreme Court permits to even single out a positive trend, because the only the Supreme Court and the Constitutional Court being the two Supreme Court bodies. However, there was a good intention, and I think we can't even call it a good intention. This was making the intention to be good, that the law must be applied uniformly, the praxis must be uniform, and uniformity of legal practice is best provided for by one body, just one body, because both the Court of Arbitration and the Supreme Court were considering cases of the same category, and they were viewed in different systems and under the courts of arbitration. In reality, the uniform practice was well introduced by the plenary sessions of each of these courts if there were some discrepancies or discords between the Court of Arbitration and the Supreme Court. And this law was enacted on the 1st of January of 2011, which allowed to convene the plenary session of the two courts. And to think that so many different cases which were considered by these two courts, one in the field of economic activity, another in the field of all other relations, including the criminal litigation, it would be preposterous to think that these cases can be discussed during the plenary session all the time, but it could have well been imagined for some specific cases. The last thing I would like to say with respect to this whole picture, which I think is quite in harmony with my earlier statement about the destruction of the judiciary system, is the status of the judges in the Supreme Court of Russia. In accordance to this law, a new Supreme Court was created, which by far is not unifying core of the two courts, because not all judges of the Supreme Court of Arbitration and of the Supreme Court entered this new court. The most destructive procedure was the procedure of selection of judges for this new court. This system, which complies with the Constitution, it has been preserved, and the regulating acts continue to work. And this system never allowed for the judge who is and has been appointed by the president, and especially appointed into the Supreme Court by the Council of Federation, could be ever stripped of his authorities without the specific legal grounds as stipulated by the law, which is clearly if the judge has lost the citizenship of the Russian Federation, or got engaged into business and entrepreneurial activities, or if he or she is sick, if he is found missing, is he gone missing, and recognized as such, or else tried and convicted, all these legal grounds quite transparent and understood, then it is quite obvious that such a judge cannot stay in this power. There was one other important peculiarity whereby the judge can be stripped of his authority if he or she have found incompatible with the high status of the court, the high values of the court. And this indeed requirement was indeed used quite arbitrarily. I can quote an example of one judge who was dismissed because at a session of the Council of Judges, of the presiding judges in a region, he criticized the financing of the regional court. So he spoke critically about the procedures of using the finances for supplementary payments to the benefit of the judges, and which is primarily used, and for that he was dismissed. The Constitutional Court upheld his case, but at least there was a way to check for how justified the dismissal of the judge was. Nowadays, with having the same legal grounds, a new and I would say an extraordinary law was adopted. It is called the Law on Special Qualification Collegium of Judges, which was created as a temporary body for 6 months to make an investigation into the all judges of the Supreme Court. And this qualification commission had to make a decision with respect to a federal judge appointed by the Council of Federation if he or she may continue to serve as judge. So this is indeed a blatant violation of the principle of irreplaceability of the judges, which is a total ignorance within negligence towards the status of the judges. More than that, this specialized qualification collegium acquired the right not to recommend those judges which had reached the age of 65, even though the general legislation age for a judge continued to be 70. So, indeed, this is quite an arbitrary thing unless we look at how these norms are truly applied, because we can see how this special collegium or commission was telling every judge that he did not want to keep in service, was explaining to this judge that you're quite good, you have considered and taken all these verdicts, and there are no cancelled verdicts, but he cannot be recommended. Why? The ground is the grounds were not given either in the law or in the documents, and the actual reasoning given by the special services were quite obvious. Now, they were quite different. It would be difficult to enlist these in a coherent text. For instance, a brother, sister, wife, or son or daughter worked at the legal in the judiciary system, in the judicial system, could be in the Far East. This was said as a conflict of interest. What kind of conflict of interest? There are processual rights which, when considering a specific case, and when it is seen that some people that there may be a conflict of interest, then such a judge is dismissed even without any special collegium. But this processual instrument was not sufficient, so they decided to dismiss the judges if he or she has any relatives working in the judicial system, which I think that this is a discrimination by profession, on the grounds of profession, for either the member of the family or else for the specific judge who is thus dismissed, who could not continue to work in this body. But this is just one case. What about other cases and the attorneys? So, but this ban was never formulated. If he or she has ever changed their name, even in decades ago, this was also given as a ground for the dismissal of the judge. This was also the case. A judge could be dismissed if he or she had relatives engaged with entrepreneurial activities. As a result, we have a Supreme Court which could not be formulated, composed in 6 months. And I can give you some data from the criminal court collegium, which had to have 60 judges. Only 30 have been left, and these 30 positions which are now occupied were not necessarily filled with the previous judges of the Supreme Court. And there were even those judges who had never worked for the legal system before. Those who passed an examination for the first time and gained the right to be nominated for a federal judge. Well, to say that this is the way to provide for the unity of practice would be quite irrelevant. The judges are in such a position when no word can be pronounced by them without censorship, either on behalf of their own internal censor, and the main task here, the main task, which is that the court is a body to uphold the rights, and the main idea for any judge who wants to keep his office is something quite different: the fear for his or her seat. Thank you. Colleagues, Boris Grazowski has long wished to ask a question. Thank you very much. Thank you for a brilliant presentation. Two questions, and I apologize if I may not be quite versed in the reform of the legal system. But my question is that why is it that the legal reform was only initiated on the eve of the year 2000? Why is it that there were no serious attempts to undertake the legal reform in the 1990s? Even though there were some jurists in the government of Mr. Gaidar and Mr. Yeltsin's staff. And my second question is that it is well understood that things related to the rights of the judges, the interests of the judges' corps, this is quite important. But do you not believe that the judiciary is a bit too preoccupied with the defense of their rights, and in doing so ignored many valid or valuable reforms? And in this way, it becomes a situation when it is difficult to reform the judiciary from the outside, and it is very difficult to be reformed on the inside. As an illustration, it is clear that the judges were very concerned about the replacement by Mr. Yakovlev with Mr. Ivanov, and it turned out that he did quite a few good things. No, thank you very much for good questions. Let me be concise. It is not true that there were no attempts to initiate legal reforms in the 1990s. It was exactly in the 1990s when everything was done for the judicial reform, which was indeed reflected in the Constitution of 1993, a constitution which would not have had the formulations of the court as an autonomous organization. This reform started on the basis of the Supreme Council of the Russian Federation, and under the government of Mr. Gaidar, for the first time, the reform was approved, and the concept of the legal reform was first introduced. And the judges at that time were quite happy to move in with these reforms. I remember a judge in Germany, one of the lower circuit judges, once told me that she was satisfied with what she does in the following words: "I'm truly independent." And the Russian judges were indeed elated to have this independence. They were happy not to have to take the cases for the consideration by the party bodies, and the same pertained to the voting when only one candidate was nominated, and every 4 years, every 5 years, the judge could not feel himself or herself independent. So these things were removed thanks to the reform of 1993. Some fundamental laws, including the law on the status of the judges, were adopted in 1996. The law, the federal constitutional law on the system, which was a good law. The main tribute to this law was that in accordance with which the judiciary power and the power of courts in Russia was to provide a single standard of justice. And this was all of these laws were adopted throughout the 1990s. And at the very same time, the jury was first introduced, first in 10 regions, and then the number of the regions started to grow. And it is good that you've mentioned Mr. Kozak, because starting from the year 2000, a counter-reform started. And this counter-reform was indeed started by the government. And what we're seeing today is called the true economic reforms, whereas the 1990s were viewed as the calamity for the Russian economy, even though the economists can say that the Russian economy was on the brink of collapse. And it was the government of that day that provided for Russia, and all of this has been well forgotten. And clearly, this has been dictated by the political interest. And now, with respect to upholding the rights of the judges. You know, when this was indeed one of the intents of the judges, in the first years, there were no attempts to prosecute the judges. I had the honor to teach for the qualification commissions. I have to tell you that I spend a lot of time trying to explain to these qualification commissions is to see if the actual litigation against a judge was it not dictated to take a revenge on the particular judge, or else to exert pressure on him. This, of course, was the judges were never defended, and the judges were indeed responsible for making the conclusions about the validity of such claims. And I have to tell you that there are several factors. The Supreme Court, when the Russian Constitution was adopted, when the law on the legal system was adopted, the legal initiative was preserved. And it was said that that the legislative initiatives are directed at regulating the procedures, but the laws were actually adopted by the parliament. It was quite difficult for the parliament to work because there are not many lawyers or barristers in the Russian parliament, and this is not good because I always thought that the Supreme Court must not have a legislative initiative. Excuse me, a legislative power. It may have a legislative initiative, but not legislative power. I think that the court system can be reformed on the inside, but when I'm asked what needs to be done to conduct such reforms, and in the context of democratic reforms, the only important thing is for the government to follow the reforms. But the government hasn't and doesn't do that. And it appears that it is very difficult to change oneself on the inside. But of course, there are some cases that the legislator may introduce. And this procedure is the procedure for electing the presiding judge. That person who is the chairman of a court must not be dependent on anybody on the outside. Such a person must be elected by the judges themselves. And I think that Veniamin Yakovlev would not have left, even though I think that he might have left for age reasons. I have to tell you that when somebody is dismissed because of pension age, this is also a pity because Mr. Yakovlev was indeed the person who created the courts of arbitration in the new Russia. And indeed, in the Soviet times, the Supreme Council or any other legislative body could well be considering the economic cases, considering, for instance, the relations between the Izvestia newspaper and the government. Before the Constitution of 1993, we lived with such a division of powers. We will continue. Thank you very much. Anton Petrov from St. Petersburg. Thank you, Tamara Georgievna. I'm a lawyer, and we have heard that the main criterion for selecting the judges was the availability of an residence in Moscow. Do you not think that the problem is a lot wider than just the status of the judges? And many young lawyers, young jurists feel that the crisis is quite comprehensive. It deals with the matters of reputation, with the theory of law, with the Institute of Attorneys, the barristers, and it appears that the Western law firms which had existed and worked in Russia exactly because they were not contingent on the court trials here, and they may well leave Russia. Who knows about that? Do you not think that the situation may even be deeper, which is that the peculiarities of the Russian law as received from Germany and allowing for such a phenomenal freedom for every subject of this system, and that this may not serve as a basis for the independent judiciary, and that even in Germany this system had changed and we are still following the example of the 19th century Germany.
I would agree with what you have said about the last point. It is not that we have a German system, they have our system, because our charters approved by the Nicholas II was the foundation of the criminal law and the court activity which operate in Germany now, and there are certain changes, no doubt, but in Germany they didn't bring such serious consequences as in our country. This system didn't remain the same. The system introduced by Alexander II was our own system, not American, neither American nor English nor German. It was our own system, and it did not retain itself, although it was built by wonderful lawyers, and it operated well. But at that time, the country also achieved the state when counter reforms were nearby. Thanks that you also presented the point of view which I have been expressing for many years, meaning that in Russia we face the phenomena which may be called crisis of the law. It is true about the legal profession, it is true about legal science, and it is true about legislation in general. In all these areas, this thesis is true. By the way, we also have a crisis of legal education, meaning that recipients are our citizens, so their legal conscience is distorted because they are told that they have legal nihilism. Actually, the authorities have legal nihilism, and people just adjust themselves. Instead of using their right, they know that they have to pay for it. That's it. Of course, it is total disrespect towards law, and that's why this crisis makes the legal profession. Actually, I like this profession very much, but this profession becomes such that a lawyer in modern Russia constantly should think about how he may continue to be a lawyer. I know many lawyers who left the Bar Association. I know that there is a new law being discussed about legal profession, about lawyers. The law which is not actually presented to the professional legal community, neither to the society in general, and the point is to turn advocates into the commercial institution, as distinct from principles which base the legal activity now, meaning that the legal activity is not to attract money, and so advocate structures will be commercial, and they'll have to pay taxes. So this is a legal entrepreneurial activity with a legal tax-paying system, with a lenient tax paying system. There is a Maastrichtian law about introduction of the principle of objective truth in criminal law, meaning that the truth at any rate should be reached by everybody, including court, meaning you have to reach a confession. The court will be looking for evidence which is out of line with everything which you have accumulated in a positive way. If you remember Yuri Dombrovsky, there was a faculty of wasteful things. Wasteful. See, you don't need it any longer. So I am totally in agreement with you. This crisis does exist. Stanislav Avramenko, Rostov. Stanislav Stansky, school graduate of 2012. Dear Tamara Georgievna, I would talk about Constitutional Court. In our case, on the condition of authoritarian political regime, it is more or less clear. And you can consider the role of the Constitutional Court separated from the general context of disruption of the court system. It's rather of theoretical nature, I mean, my question. Constitutional Court thinks that it has no right to consider constitutional amendments. But in the Constitution it says that no Constitution stipulations, okay, so let us imagine that the constitutional amendment is more and more sinister in the area of supremacy of law. Now let us consider the extreme case when a constitutional amendment stipulates that the Russian president is elected for life. This is out of line with the Republican form of government. So what shall we do with this blind alley? People have the right to expect fair legal protection and legal laws. And this is a very professional question, and I respect Stanislav, and I know his studies about constitutional law. The question is quite right, and you have described its solution. It should protect the Constitution. That's what the constitutional law is about. The text contains several decisive items for this protection to be real and possible, so that the Constitutional Court may counterpose a legislator, including a constitutional legislator. And there is a body of legislators which may introduce amendments to the Constitution. So, the constitutional texts say that nothing in this Constitution may counteract with the stipulation of the first two chapters. And this is number one. The constitutional text says that if anyone wants to change the text of the Constitution in contradiction with these two chapters, you require another procedure to make a constitutional gathering, put in a new draft of the Constitution. But the Constitutional Court, when it checks upon normative acts or when it interprets the Constitution, it says that there should not be any contradiction to all other stipulations of the law. You check. What shall you do? So that's the other items were in keeping with this initial principle items, because you have to interpret other chapters in line with the first two. So there is a federal constitutional law on amendments, and the Constitutional Court may be checked by the Constitutional Court, and such cases took place. And then the competence of the court is to check the content of this law about the constitutional amendment, whether it is in line with the first two articles, and you cannot deny this. For constitutional jurisdiction, it is very important to have one thesis. This jurisdiction itself determines its own competence. Nobody can determine the competence of this jurisdiction. So constitutional courts have a certain function, which is competence by definition of competence. This is the prerogative of the Constitutional Court. Otherwise, it is helpless. And it follows the demands of the dictatorship of the law. So the Constitutional Court limits its competence in many ways, because constitutional judges elect their own leadership every 3 years. In the past, 19 persons, members of the Constitutional Court, received a list of 19 persons and marked their own preferences. Who, to their mind, is better for these positions of the leaders? The 3 candidates were elected who received more votes. On the second stage, out of the 3, they chose 1 who received the majority of votes, 10 votes. And this procedure was considered to be the best out of all procedures of obtaining responsibilities of the Constitutional Court leader all over the world. We want to spread this onto all our courts, but it didn't work. And in the Constitutional Court also it was blocked because the chairman is no longer elected. And now actually the chairman is in the lead, and the president may assign him as many times as he wants for 6 years. So if you are independent, I mean not a local judge, but a constitutional judge who put forward with his own opinion what is the end of this story, he has to resign. Maybe it's not so good for me to talk here in front of people from St. Petersburg, but when Constitutional Court moved to St. Petersburg, it lost its independence completely. Not only external independence, but internal, because all the science in the Constitutional Court turned to be local. And you see who are assigned. All recent assignments are related to well, being from St. Petersburg, or to being from St. Petersburg University, or to other forms of interaction with this legal structure. I'm sorry to say that the public right in St. Petersburg University since long time, since the Soviet time, had one good peculiarity. It was the right, public right, including judicial right, in which chief role was the principle of law. Nobody can explain to me what it really means. If it is just the demand to follow the law, then what is the difference from notion of the norm, which is obligatory for everybody? Even in St. Petersburg advocature, where there are very good advocates, they develop their mutual stand towards how a lawyer should behave during the criminal process when he defends someone who does not say that he is guilty. So they said that a lawyer should secure legality in his legal activity, and if he thinks that the accused is not right in saying that he is not guilty, he cannot support such a position, which kills the profession of advocates. Who needs an advocate who goes to the state court to support the interests of the state law? These are the sources of changes or transformation, not only of a paradigm of the Constitutional Court in Russia, but its legal stand, which is different now, because the Constitutional Court recognized now that it should not, that in 2013 it recognized that the court may and should, following its own initiative, demand from the prosecution collecting additional evidence, and prosecutors should give heavier, should present to the accused the heavier crime that he really committed. Artem Tarchinsky, Moscow. Many experts say that all their advices are not for these authorities. Suppose the authorities change, and you need financial independence of court. Yuri Lushko, for instance, corrupted the Moscow court by giving apartments. What should be done for independence of courts? The fixed rate in the federal budget or something. Charles de Gaulle once made a reform by substituting all judges for graduates of legal departments. Is there any personnel reserve of this kind? Well, the easy question is financing of courts. Of course, there are different ways for financing, not to give dependency. Financing is done through the budget, and the funds are to be in keeping with the necessity of performing independent justice. That was very good, and judicial budget was not to be sequestered, and Constitutional Court interpreted our act about ratification of the convention, which said that Russia promises to take steps to secure finances of the judicial system. So it was not yet reached, and that is true. But there is another danger here. You may make courts rich, but they will be dependent, and that's what we have now. Judges have big salaries, not at the lower level, not at the level of the first instance, and they cannot earn now. They cannot get high qualification classes or rates, which would give them additional salary. They are limited. They may reach only level 7 in the region, and in the court of the first instance it is even less. So development is also reverse here, and qualifications are assumed on the basis of big support of the chairman of your court. There are other ways of financing in the world. There are finances that come from the budget, and in Belgium, the head of the Cassation Court sends to the Belgian Parliament a note. Dear Mr. Chairman, I inform you that for the next year, the court and the judicial system, which I head, require financing in this or that amount. And then there is one phrase: I am ready to serve you in case you have any questions to this effect. And the federal budget may have imputed percentage figure, which cannot be changed. For the third year, we approve of the program of the development of the judicial system for a certain period of time. It was 7 years, now it is up to 2020. So the court system, it says, should be given 90 billion rubles, and then there is a list of how it should be spent. Judicial department distributes money, and some specific court may not get anything. Such measures are necessary and required. I forgot the second part of your question. Yeah, personnel resource. And this is an enormous problem, and it was made clear when the new Supreme Court of the Russian Federation was formed. Where can you take these people who may fill all the positions in the higher court of the Russian Federation? One thing that you look for people who want to work in court when you get a status of an independent judge. And another issue is the second option. And there are not too many people who want to go to this kind of work. In the high school of economics, there were polls among our students about where they want to work. So in the past, they wanted to work in commercial structures, in advocature and in courts. Now, they want to work in the state bodies of investigation, the prosecutor's office, in the investigation committee, in the Ministry of the Interior, and so on, because they understand that the status of an official is protected there. And not a single university can prepare so many people. So my question was, do we have a potential of total lustration of current judges? No, the answer is no. It is undermined by the system that's introduced today for higher legal education, which is bachelor's and master's. In case of a judge, you should be at least a master. Have a look at the legal programs and people who study on to get master's degree, and you see how many of them are there. It's minuscule. And our legal education is given to someone who doesn't want to work in the legal profession.
It is not available. This reserve is not available, and it is not being set up. That is what worries me. We couldn't even set up a judicial academy in the way it should have existed as an establishment that trains lawyers to probable accession to be the judge. We don't have what we do have with Judicial Academy. It just helps to upgrade the skills of the judges who have already been appointed judges. When it was set up, it said quite openly in the charter, though it was later deleted, it is set up, amongst other things, for the purpose of training children of the judges. Do you see what I mean? Then they deleted it at the first stage. Well, this is how things stand today about the legal education. So, dear colleagues, the last question. Tamara Georgievna, the question from Parfenov, Novosibirsk region. A number of experts from the judicial system saying that people from the prosecutor's office enjoy appointments to be judges. So to be appointed a judge, this is something they seek. Tell me, please, how relevant the problem is today, and how does it discredit the court and makes it impossible to have a fair and equitable examination of the case later on. It is worse than what you say. We must take a look at what groups are maybe in reserve to be appointed as judges. I mean reserves in the social sense of the word, not in the officialdom sort of perspective. They are quite a few, those people. Few. They're mostly people from the investigation committee, from the prosecutor's office, from the Ministry of the Interior, which is like something like in Russia, and then people who work in the court per se, who might be taking minutes, who might be busy in document over in the archive, may have been assistants or advisors to judges, but who have already accumulated the atmosphere of judicial activity. They have no other standards to guide them in judicial activity other than that. The system of selection of judges, there are sort of two lines in the world, if we look at the global practices, how to select judges. The first is professional selection and appointment, and second is bureaucratic selection appointment. Professional seeks to identify in a candidate his personal capacity, how good he suits the position of a judge. This implies tests and written tests, and whether to see if a person can quickly produce a legal text, as well as drafting verdicts, like in role play, which can be analyzed. So these are objective things. It's not that, look, I'm keen, you're keen, and I like you, or I dislike that person. No, these are objective criteria. And this is what we call pure professional selection. For that matter, elements of professional selection are set up, but in purely formal requirements that do not really give us an idea what a person should be like. Is that he should have a track record, legal background. For that matter, we need to clarify that it has to be necessarily a master's degree as a sine qua non. And at that, he should have 5 years track record. For that matter, you're having a master's degree doesn't bars you from taking the judge's position if you're say baccalaureate is not in law. So it's basically destroyed the system of legal education. Where do we draw the personnel? Where do we draw people who can become judges? And as to those who are allowed to go for the professional education abroad, to assume a judge's post, so those people who before worked in police, in prosecution, they introduce what they call professional quarantine. Before they assume a judge's position, they should have worked, well, no less than a year or two. It depends upon the legislation on a specific country, somewhere else, which will sort of get them rid of the professional patterns that are already instilled in their mind. And instead of this being prone to accuse rather than to be prone to defend. And it doesn't have to do with judicial things at all. For example, if they examine the cases when the judges will be challenging government or legislative acts adopted by the government. So the state that has a number of weighty factors that might really crush anybody. This is not something that suits a judge. Another way is to train people specifically to become judges at institutions like Judicial Academy, just say. And this is something that is not being done in this country. Dear colleagues, as a lesson to Tamara Georgievna, I thought, what excellent perestroika we shall have next. How much garbage in terms of legislation, how much fresh air we shall see when all this we will be putting back into order. And as to would-be legislators, I could only envy them. Well, unless they shut down the windows to let in the fresh air, we must hope. I suppose the whole of legislation will have to be rewritten, because the law about the aggressor, you may have heard it in the news. This is remarkable, remarkable. One innovation is better than the next one. I rejoice when I read these papers. Tamara Georgievna is giving us an honor by presenting here every year. She's a remarkable, a very well-versed expert, and we hope that this tradition will carry on. She's a brilliant expert, as we had a chance to. And let us thank our speaker. And I wish to thank you too. We adjourn for a break.
Мне хотелось бы узнать ваше мнение как экс-судьи Конституционного суда по поводу такого понятия, как президентская квота в Совете Федерации. Для чего это?